Committee.
Not to be arrested. It's not.
This Wednesday afternoon, April 9th. Actually, before we go to March, we're gonna go to Kurt, because I think Kurt's got a much shorter bit. He's only gonna comment on one section, which is section 26. Kurt, thank you for being here. I hope you had a good time wherever you were, like somewhere that wasn't Vermont, but you don't have to disclose any of that. I understand, but thank you for being here on fairly short notice. So.
No, you're welcome. I'm happy to be here. Thank you. And I did submit through Nate a letter that I wrote on this portion of the bill on February 7th. So that should be in the record now as well.
Okay, great.
So for those of the committee that don't know me, I am a family law practitioner, and I've been practicing in the area of adoption law since 1995, a year before Title 15A was passed. And I'm just addressing, I think, I don't have the whole omnibus bill that you're looking at, but I'm looking at H7, which restores the language to the termination statute in 15A, section 3-504A2A.
I think it's section 26.
Okay. All right. I don't have that with me, but
Same exact language, so that's fine. We proceed.
okay, great. It's so this what's proposed is restoring the language that was in the initial bill, the initial legislation, which allowed the court to consider whether a person in looking at the termination of parental rights, will allow the court to consider whether a person had been paying support while legally obligated to do so within their means. So the statute specifically addresses the fact that it has to be something that the person can afford. And when I saw that the section had been repealed last year, I was a little bit perplexed because I couldn't understand why that had been done. This just gives the court another grounds to look at determining whether a person has exercised parental responsibilities. And you know, I was also curious about it because this statute is broken into two subparts. The first half is for children under the age of 6 months of age, and then the second subsection is for children over 6 months of age. And it did not delete the financial portion from children under 6 months of age. So I wasn't sure if there was a reason for that, but I'm just recommending that the court, that the committee restore the statute to its original language, which will allow the court to have that financial piece to consider. I just finished a trial in which the respondent had been in and out of jobs and had been, paying child support when he could. And then actually during the course of the trial, he paid $5,000 toward arrearages. And because that section of the statute had been repealed, it really wasn't even relevant for the court to consider. So this really cuts in both directions, both for prospective adoptive parents and for respondents. And I don't see why the court shouldn't have the ability under the statute to consider those financial contributions. It's not uncommon for me to have cases where there's been no contact between the biological parent and the child for years and years, and there's thousands of dollars in child support arrearages. But with that section of the statute deleted, the court couldn't even consider that in making a determination about whether or not to terminate parental rights. So I'm just strongly recommending that the committee accept this amendment restoring the statute to its original language. And I'm happy to answer any questions. I've tried a lot of these cases over the years.
So I will have a question, but I'm going to just, we are going to have somebody from DCF, but last year when this language was struck, we reached out to DCF to understand the rationale, and This is what they said, and I'm only reading this, even though we're going to have DCF in, because I have a question based on what they were saying. They said that this change would remove non-payment of child support as grounds for termination of parental rights. While termination of parental rights proceedings are complex and a variety of factors are considered when making these determinations, the effects of poverty cannot be a reason for separating children from their parents. The removal of this language from statute promotes DCF's overarching goals of supporting family reunification when safely possible, as well as our commitment to trauma-informed responses to support families. Additionally, the removal of the statute reflects DCF Family Services Division's current practice, which is not to consider payment of child support in TPR matters. Striking this language would make it clear that Vermont does not seek termination of parental rights because a parent does not pay child support. So that's DCF, but you're in situations where DCF is not involved, and
Yeah, DCF has nothing to do with these proceedings. They're not a party to these proceedings. You know, they're talking about termination of parental rights under Title 33 in the juvenile statutes. There is no way that DCF could even be involved in these cases. These are not kids that are in DCF custody. DCF has never been a party in the 30 plus years I've been trying these cases. And the statutory criteria has always been completely different. And as I pointed out, the statute specifically says that the payments have to be in accordance with the respondent's financial means. So if someone puts on evidence that they can't afford the payments, a court is not and cannot terminate just for that. And then there's also a subsequent section which allows a respondent to put on evidence by a preponderance of the evidence that they had good cause for not complying with a certain section of the statute. So there's no way, the way that it's written, that a court could or would ever terminate someone just for the non-payment of support. So I'm perplexed about DCF is not involved in these. These are tried in the probate division.
So did they strike the language from the wrong place? I mean, this is what they asked, where they asked to strike it. I'm looking at the bill related to that.
I don't understand that.
Okay. All right. So interesting. All right. Well, we'll talk to them about that certainly. And I guess then my second question might not be relevant, but I'll go ahead and ask anyway. And that's I was just looking at on page 20, line 19 to 21, that in making a determination on the subdivision, the court shall consider all relevant factors, which may include the respondent's failure to pay child support. That seems a little awkward or odd. You know, they shall consider these things, which may include these things. Why doesn't it just say a determination under subdivision may include the respondent's failure to such and so? Maybe that doesn't matter. I was just wondering if that would change it for DCF, but that's not what I'm hearing, that shouldn't be relevant one way or another.
Yeah, I think it's the way that the statute is worded, it is that as you said, it may include those specific things, and in the proceedings and the petitions to terminate that we bring, we concentrate on the ones that are specifically enumerated in the statute. But
right.
The court, it's discretionary with the court. But again, the repeal of that subsection, especially when it's left in for children under the age of 6 months, kind of puts the trial courts in a bind, because it really seems as though they're not allowed to consider the payment of support or non-payment of support. You know, as I said, if you've got a respondent who's making support payments in accordance with the best of their ability, and they want to use that as a way to fight the termination of the parental rights, you're almost taking away the ability to present that evidence potentially. So repealing that subsection really caused, in the case I tried last month, it caused some consternation in the trial court, and I'm just
Right.
puzzled. I'm puzzled about the reasoning behind it being taken away.
Okay, appreciate that. Ian.
I just want to say I wasn't here last year.
All right.
So, no, yeah, that's all I want to know. I'm not testifying. I was just wondering, if while we're here, fixing this potential mistake, could we, and I think this is kind of to Martin's point, could we change the language in lines 19 through 21 on page 20? I'm just thinking about the example that you just used around the father's payment of child support. The way I read this, even if we we bring this language back in, I don't know if could you actually use that as evidence because it's not a failure to pay, but it was actually him paying the child support. Like, could we clean this up a little bit, or am I just overreading this?
No, you're not overreading it. I understand what you're saying, although the enumerated subsections all concentrate on the respondent's failure to, so failure to make payments, failure to regular communicate or visit with, and failure to have the ability to assume custody of the child. So the way that it's structured, that, you know, that is how it's worded. I wouldn't, you know, I think a respondent could respond to that by saying, well, I didn't fail to, I have made reasonable and consistent payments in accordance with my ability. That's sort of how the evidence goes. Most of these cases, most of the cases turn on the lack of involvement with the child. So that's really where the bulk of our evidence is, you know, and is there a good reason why the person didn't have contact with the child? But again, the failure or the you know, the failure to make payments, or if the person's actually been making payments, those, you know, we're just asking that be a relevant consideration for the court. You know, if you're.
And yeah, and I appreciate that. And I guess now that I'm reading this another time, I guess you could just say that payment of child support would be considered in all relevant factors. That would be a relevant factor would be his payment of the child support. So yeah. Huh.
Right. And then I think what you're getting to also is in section 3504 subsection B, if the respondent has proved by a preponderance of the evidence that he or she had good cause for not complying with those various failures, then the court can't terminate. So I think the way the statute is set up actually provides for a respondent to rebut the negatives in the previous section, if that makes any sense.
Yeah, it does make sense. Yeah, I guess it feels kind of clunky, but yeah.
Yeah. It does on first reading. I guess I've been working with it for too many years that it seems to actually flow pretty well in practice.
Well, I definitely trust your opinion on it.
In that case, we'll leave it as it is.
Yeah.
We'll just get it back to where it was.
Right.
All right. Well, I appreciate it. And we'll probably have DCF in at some point. But understand where my first question will be, is DCF even involved in cases under this particular provision? So,
All right.
I really appreciate your time. Thank you very much.
Well, my pleasure. Thanks for the opportunity. All right. Bye now.
So I might, unless you have timing, I might go to Judge Zoney first because he's already covered the first 18 pages of this in previous testimony. So I'm expecting Judge Zoney will be shorter than, is that okay? Okay. Judge Zoney, thank you for being here. And thank you for, well, I'm assuming you've been patient, but thank you for being here.
No problems. Thank you, Tom Zoney, Chief Superior Judge. So on page 18, section 25, the firearm surrender work group. The only comments I have about that are, it does not have anyone who is designated to be a chair and call meetings. And so it seems, I would use a boating analogy, it seems rudderless as to who's in charge to get things going and head things up. The, I would also note, there was a question earlier about what's the difference between a task force and a working group. I think I may have figured it out.
Oh,
If you look on page 19 and 20, lines 20 and 21 at the bottom of page 19 say the report shall include, and then you go on to page 20, a workable statewide compliance model. In other words, what the task force is charged with doing is coming up with a model. It's not a question of should you, it's a question of you shall. In comparison, when we get to section 33 on the probate guardianship, it says the report shall recommend whether. In other words, there's a difference in how you approach it. If it's a policy of the legislature that you are deciding this is something that we're going to go forward with in the legislature, and we want you to tell us how to do it, then you would use this language. If the idea is to study it and determine whether it's appropriate and whether something can be done, you might want to consider changing the language.
did you just make that up, or did you?
It sounded convincing.
It sounded very convincing, though, I have to
But
say.
it really, every now and then I try to get something right. I don't know.
Oh, I appreciate the distinction.
My
We'll-
understanding.
Okay, all right, well, okay.
But
Yeah,
it-
we're asking.
Specific task.
Okay, yeah, I like it. I like it. I think it's good.
I confess, earlier this session, I was asked by a legislator in another committee, there was something they were putting together, and it came out and said that the group shall. And I pointed out that, well, if you're saying shall, you're telling us what the answer is already. And why don't you, would you prefer that we actually study it and tell you whether we should? And then if we should, we can tell you how to do it.
Yeah, no, that makes sense. So let me back up, and I have another question. Just the Fatality Review Commission, does anybody know who chairs the Fatality Review Commission? So it's the AG or AG's. All right, so I would suggest for the task force that we use the Attorney General or designee as the chair to call meetings and such.
Yeah, but they,
So if we
yeah, we
can-
can add that part. It does say they convene, it has to be convened by the AG under line 3. But we will certainly, you can put in that they shall be the chair too.
Okay, all right, appreciate it. Okay, back to you, Judge Zone. Thank you.
Right, on page 20, section 26, I believe the expression is what he said, and that's under the grounds for terminating to be returned. I really, nothing much to add to what Mr. Hughes said. He articulated it very well. It's a factor that cuts both ways, actually. And so if you return it to where it is, that makes sense. And I would have to acknowledge, I do concur with his assessment that it makes little sense to keep it in for under 6 months old situations and to remove it for the older children. So I would have no objection to that being returned to the way it was.
Okay.
On page 22, the section on bail revocation and appeals, and that goes on to page 24 where subsection C2 is added. That is consistent with what was discussed when you we're looking at H409, and it clarifies that the state does have a right to appeal in a way that is clear and gives them that right. Representative Arsenault asked a question in response to that about whether race data could be tied into the revocations. The judiciary does not get those two data points in a way that they can be connected. And so we do not collect that type of information to be able to address that. Do you want me to address the issue of the new request for disrupt, or I'll just leave that to the committee?
You're welcome to tell us that that's a policy decision, or unless you have more than that. But yes, why don't you go ahead and address it?
I recognize that the word disrupt is the word that the Supreme Court uses. It's also the word the Supreme Court has defined and would define the parameters of during any appeals. Yeah, and so I would say that whether or not to adopt a specific definition by the legislature for the court to use during its constitutional analysis would be a policy decision.
Right. I think it's just as good for state's attorneys to make that argument based on facts in a particular case, but that may just be me. But you don't have to respond to that.
There was a question I know Representative Goodnow asked relating to the victim notification and Odyssey. We are not involved in those proceedings. That comes after someone is in DOC custody, and Odyssey would not be configured for that at this time. The final on page 28, the probate guardianship. Chair Lalonde, you indicated that this actually derived from H26, and that is correct. H26 is a bill that sought to make significant changes to the structure of developmental disability guardianships, putting them into the probate court. That is not something that stakeholders had uniform agreement with, and there was a number of concerns expressed by across the board. The request to do that is something that I know has been made by a number of citizens to legislators, and it's a matter that when we look at the questions that are asked by that type of bill, that we believe would be appropriately studied by a working group to determine what is appropriate, and if it is appropriate, how it would look, and the resources that it would take to effectuate it going to the probate court or all going to the family division.
Okay, questions?
Unless there's any questions, that's all I have.
Yeah, Ian.
Very quick question, Judge, thanks for being here. On page 24, back on the bail revocation appeal language, we changed on line 3 of page 24, forthwith to promptly. And I'm just curious, is that just, I don't know where that change came from, but does that, are you good with it? And does that actually, is forthwith different than promptly in any way?
I think forthwith, the dictionary definition would be, I think that would be immediately, and promptly is same place, basically.
Okay.
I can tell you that when I see those two words, to me, it means do it now.
Line 3. I only asked, I know it's not, I'm not trying to be nitpicky, but we're talking appeals that need to happen really quickly, right? So we are changing.
So on the extradition bill, there was an immediately there, and I suggested that we should change it to the language that was elsewhere in that law, which said forthwith. And the response from Michelle was that forthwith is archaic language that they're moving away from. And so that's why it's changed to promptly, could be changed immediately. So that was my understanding. So my other question was, well, why don't we change the forthwith elsewhere? But this is one of the forthwiths that gets me. I mean, forthwith is a legalese kind of word, right? I mean, as opposed to promptly.
And promptly certainly indicates to the court the importance of dealing with it immediately, whether or not that's the word we use, but we understand that.
That's what I wanted to do.
Immediately sounds too in his face. You know?
Yeah, it's too harsh.
All right. Any other questions for Judge Zoney? Thank you very much. And I know that I was gonna have you weigh in on the latest H230, which I sent you, but the committee hasn't seen. But if you can verbalize your viewpoint of what they will see probably tomorrow. So I'm not just relying on the email where you said that looked fine.
H230, there was some language about when I testified previously about whether the state would need to do warrants or need investigation. And what I indicated was in the new language, it used the word in relation to, and I would support that. I think it's clear. I think it is unquestioned, and it works.
All right, great. Thank you very much.
What bill was that?
H230, which
H230.
we looked at, and you came up with the language that he just blessed. So
Oh,
like,
let the record reflect.
it's wildlife going civil into.
Oh, and taking out even more of the language that's kind of
I noted that I was on the schedule for H331. Are you still going forward on that later this afternoon, or is that going to be moved?
Moved.
Okay. So you don't need me anymore today.
Well, let me ask. I mean, are people excited about having yet more testimony after? So no. Thank you very much. We're going to probably move it to next week sometime. Appreciate your time.
That's great. Thank you. Have a good day. Take care, everyone.
Thanks. All right. So Marshall, thank you for.
So, thank you very much. Marshall Paul from the Office of the Defender General. This is our first time to testify on the bill, so we're going to be starting from the beginning. We don't actually have a ton of comments on this bill, so our testimony shouldn't be too long. But I would start out on page 5 with section 8. And that's the provision that is repealing the ban on switchblade knives. I was not actually involved in the drafting or in the Senate version of this, so I'm not sure where this came from, but I suspect where it came from is that there was a Massachusetts Supreme Court decision just recently where they decided that prohibitions on switchblade knives are illegal under the Second Amendment. The Second Amendment has commonly been interpreted to refer to firearms, but when you read it, it refers to arms. And switchblades are, as the Massachusetts Supreme Court cited, arms, and a blanket prohibition is therefore unlawful, which I think probably explains both the repeal of the prohibition and also the expungement. That's typically what happens when a law has been declared unconstitutional, is there's follow-up legislation to expunge convictions under that law. How many convictions for switchblades there's been, I don't know. I've never actually had a case on this under the switchblade statute. I've had cases under the brass knuckles statute, but never under the zip guns and switchblade statute. And so that actually gets to our first point, which is in a quick email to other defense attorneys, I did find other defense attorneys who had actually defended switchblade cases. Nobody had ever defended a zip gun case. And I had to go searching on the internet to figure out what zip guns were. It's terminology that's like, goes back to like West Side Story, seems to be when it peaked. And they kind of stopped using it after that point. They were actually typically guns made out of, you would take old car antennas that were extendable, pull up and down, break them off, stick a .22 caliber bullet at the end of it, put a rubber band around the end of it, and then you could let go of it and it would shoot forward, hit the center fire of the .22 and fire. And so it was like a kind of improvised street weapon way of shooting a single shot .22. I cannot.
What?
You can break off an extendable car antenna or a truck antenna before they had the
Radio antenna.
You said, and
so if you break off the old ones, they happen to be this right diameter to fit a .22 caliber right in
I
behind
like how
it.
you're now describing how to make a zip.
I had to look this up on the internet today because I was trying to figure out what zip guns were. And so you do that, and you put down a rubber band around it so that you can pull the extendable part of the antenna back. That little thin part at the end will hit the center of the .22 and fire it. And it was apparently a thing they did in like West Side Story is the only place I can find it actually happening. So our proposal would be to just strike the whole section. Honestly, I think anything that could be considered a zip gun also would now fall under the new law that says that homemade guns have to be serialized. The ghost gun bill.
Not really, because you need a receiver, and this doesn't have a receiver.
Well, this gets into the question of when does something become a firearm? And honestly,
People leave zip guns in. Just kidding.
well, our proposal would be to strike zip guns because we think that we do have, if you look back to, I always bring back the 1972 version of Title 13 because that's when our office first came into existence. And so that's our first Title 13. It's about that thick. And now Title 13 is about that thick. And I once, kind of tongue in cheek for this committee, put together a chart that showed the per capita incarceration rate in Vermont matched up with the thickness of Title 13 in millimeters over the years. I just collected as many old Title 13s as I could, and I measured them all. And you could see they track pretty closely with each other. And I don't think people are actually being prosecuted for zip guns, but I do think we have a problem with archaic laws on the books that don't get repealed, even though they serve no modern function. And I think this is one of them. And
Painted horses.
yeah, there's a lot of these.
Butter crates.
Yep. The defacing of butter crates. We've been talking about that for years and it's still on the books.
It just needs, and it's not in Title 13, I don't think.
No, somewhere else.
Yeah, so there we go.
They're pretty common in prison,
Voter crates?
zip codes.
How's it?
All right, well, there we go. There we go. So
But nonetheless, we still haven't seen prosecution.
All you gotta do is-
not to go on a tangent that you just took us on.
Yeah.
Right.
With it, but the titles expand because there's a lot additional annotations as well. It's not just that we're adding more and more laws. There's case law that gets added and added. Let's be fair on that. Did you measure that when you,
I was not looking at annotations, but I will say, I also do think that they're now printing on thinner paper than they used to, so it's gotten fat.
all right, fair enough.
Title 13 has expanded. The next one that we would comment on is, it would be the section on page 17, dealing with the repeal of the public inebriates law that's been sunsetted for year after year since Act 1 shut down. And all we would ask is keep sunsetting this. We know that Act 1 isn't open, so we can't, it's not like right now, we do need TOC for public inebriate. But I think everybody who's testified about this, including Chief Burke yesterday or the day before, whenever he testified, explained how great Act 1 was, how much better it was than the alternative. And we still have a hope that we'll get something like that spun back up and working again, because it is a better program. It does better work, it does it cheaper, and it does it more comprehensively. And I don't think anybody would disagree with that. And I haven't heard testimony from DOC. I can't imagine they want to be dealing with detoxing drunk people when that used to be something that was handled by the Howard Center, where it was a really much more sort of, and so we are fine with the provision that's been sort of sunsetted over and over again, because we understand without Act 1 there, we need someplace and DOC is it. But we'd like to still keep some hope alive that we'd be able to someday revive a program. If it's not Act 1, if it's not the Howard Center, something like it, run by someone similar that's able to do, something really responsive that responds to all types of drug inebriation, not just alcohol. Really, so we just like to keep seeing that sunsetted. I hate sunsets. I hate to see that, but we think in this case it's worth it because we think that Act 1 was a really valuable program, served a great purpose, did it cheaper than corrections did it, and we'd like to see it come back someday. And so we just don't want to give that up. The next section I'll talk about is section 25. This is the Firearms Surrender Order Compliance Working Group. I'm usually not one to say that we're in favor of another working group, because that's usually means that I have to be on another working group. But this is one that we are in support of. This has been a problem ever since we have had firearms surrender orders. The one change that I would suggest making to it does go along with something that had been talked about, which is this group has a membership and then a list of people that will be consulted. I do think that there should be at least one more addition to the list of members rather than consultants. And from my perspective, the really important one to add would be the federal firearms licensees. And that's because in the past, the way that this has happened, so I've been involved in a few rounds of how we deal with firearm transfer orders when the court orders someone not to have a firearm. And I think the reason that we have had problems with the legislation over the years is because we haven't included the people that we needed to include. And at least one of those times I remember, the legislature drafted some law regarding transferring firearms and having federal firearms licensees hold those firearms. Nobody consulted them and found out whether they'd be willing to do it or not. They're a private entity, they can choose whether to do this, and they didn't want anything to do with it. And so I think them being such a critical part of the removed firearm storage, and them having been the hurdle in prior legislative efforts around this, I think it's really important that they be included, not just as consultants, but as members of the committee.
So the problem with that is figuring out who to designate, because there's not an entity to designate which federal firearms licensing should be made part of that.
Agreed, and I have no suggestion there. I'd suggest maybe hearing from some of the FFLs and see if they, because I don't know if they have any sort of statewide organization or any informal structure, informal working groups that could be tapped to
So
do
we
this.
have Chris Bradley from the Federation of Sportsmen Club testifying tomorrow. We'll ask him that. He probably would know.
I think in past bills similar to this, Henry Perro from Perro's Gun Shop in Waterbury has also testified.
Yeah, no, he has, yeah.
So that would just be our suggestion there. Other than that, I'd say we're very happy. We don't love working groups, but that's been an issue for a long time. It's one that we need clarity on. That's not just an issue for everyone. I mean, that's not just an issue for the people who are being protected by those orders, but also the people who are subject to those orders. Right now, it is incredibly unclear what you are supposed to do when you get an order that says you are supposed to surrender your firearms. And we have had clients of ours who have gotten in trouble for not understanding what those orders mean, not understanding what firearms can be surrendered. And then we've had people who have surrendered their firearms appropriately. And then because they did not understand what they needed to do in order to recover those firearms when the court order expired, they ended up losing possession of those firearms. So we definitely are happy that this working group is taking place, happy to be a part of it. Do think that FFLs should be included among the membership, but very happy that that's in there. The provision that Kurt Hughes testified about, I will just say that is a provision that is outside of our work. And that may seem a bit confusing because I've been in here testifying about terminations of parental rights before, and here we are with law about termination of parental rights. But this is different. This is in Title 15A. This is in the adoption context. This does not typically involve court-assigned lawyers. The court does actually have the authority to assign lawyers in these cases. And I have worked on these cases not in my capacity as a public defender, but just in my capacity as a member of the bar and having been ordered to represent people in these proceedings. I will say that given that, so I'm not here speaking for the Defender General's office, but just as a member of the bar that's represented people in these proceedings, I'm a little bit less concerned about that law because from my perspective, the provision that says the court shall consider all relevant factors which may include really means it doesn't matter whether you have a list or not. Pretty much anything may be considered. So in my experience, I have not found that judges whenever there's a list that says may consider, I've found that judges really do understand that list means they may consider those factors. And if it says may consider any other relevant factors, I've found that judges understand what that means. And I don't see a lot of necessity to sort of suggesting to judges, we've already told you can consider any factor, and we've already told you that you don't have to consider any factor that's irrelevant. And here's a few factors that you might want to look at. I've found that they just look at the factors they're going to look at.
Although the only issue is that we have sent a signal by taking that out that we must not mean that we want them maybe consider that factor. So, and we took it out because possibly because of a mistake. So, I mean, I think putting it back to rights makes the most.
And like I say, it's not our office is not going to take a position on that because we don't, we certainly work in the TPR realm in the child welfare world. We don't work in that realm in the adoption domestic docket world. So we're not going to take a position on that, but I just wanted to highlight it because it feels like something that our office should have a position on, but it's just because of those two different dockets.
Okay.
It keeps us in a separate world.
Is it also your experience from you when you're were assigned cases within 15C that, or 15A, that DCF isn't involved. And
Yes, I haven't seen DCF involved in one of those cases. I don't think it's impossible for them to be involved in those cases. I can think of some scenarios where they might be able to be added as a party, but I've never seen it. So that gets me to section 30, which is the bail provision. We are fine with this. I think this clarifies law that needs clarification. We're fine with it the way it is. We're fine with the word promptly in there. We agree that forthwith is kind of archaic language and people don't really know what it means. If you asked me what forthwith means, I would say, I think it means promptly. So we're okay with promptly replacing forthwith. I think it's synonymous.
You know what it meant back then?
What's that?
When it first came out, did you know what it meant back then and just forgot?
I think I've always just assumed forthwith means prompt. I've always heard it used kind of interchangeably with promptly, like.
I'm still learning words.
When a judge says to me, you got to do this forthwith, I know I got to do it really quickly. If a judge said you need to do it promptly, would I say to myself, I don't need to do this quite as quickly as if he said forthwith? I don't know that, but
Would immediately put the fire out here in the morning.
immediately would be a whole different scenario. That
I got some words for you. I'll tell you.
Very well.
If a
The court's
judge-
closed on Saturday.
if a judge says immediately, I think that it's something I already should have done, and I need to. The moment the hearing is over, I need to be addressing this.
Okay.
There was a question about race data, and I don't have an answer to it. I just want to use it as an opportunity to say that I want to just reiterate the extent to which we do not have good data. I think that Judge Zone's answer to the question, which was that we wouldn't have the ability to put that data together, is instructive and really calls into the highlight. It just calls into the spotlight the issue that we have, which is it's so hard to get this data, and this data is exactly the kind of data that we want to be able to see whether which parts of our system work, which parts don't work, which parts have what are we doing that we are spending like tons of time and money on that has no effect at all. And we need to get to the point where we have this data. And I know I've said this in here before, but it's crazy to me that like baseball managers can look up, what's the percentage of time that this batter is going to hit a strike in the upper right-hand corner of the batter's box from a left-handed pitcher on a, daytime game in this ballpark. And they can get that data like this. And we still are at the we're looking at 3-year-old recidivism data, and we can only see 1 point of data. And I don't see any reason why at this point in the world we live in, with the technology that we have, with the amount of data that we are generating, but not aggregating in any way, shape, or form and making accessible, why I can't sit there and let's look up, probation revocations by race. I want to be able to look that up by race. I want to be able to look that up by judge. I want to be able to look that up by defense attorney and prosecutor. I want to be able to look up and know whether any of our attorneys are consistently not achieving something that all of our other attorneys are achieving, or vice versa. Do we have some attorney that's doing really great work where other attorneys aren't? I want to be able to see what judges are doing. Do we have judges that are making particular decisions that are outliers so that we can know how to litigate around those courtrooms? I want to be able to see that for prosecutors. To me, it's crazy that this data is not as accessible as financial data or sports data or any of that. This stuff is all data that we've been collecting for years and years, and most of it is still contained in paper files. The newest stuff is on Odyssey, but it's still not in any form that we can actually access it in the really kind of granular way that we'd like to.
Do you suppose it's because business? I mean, baseball is a business and you're dealing with a bunch of political stuff?
Yes, I think that if there was more money to be made in criminal justice analytics, there would be just as much money in criminal justice analytics as there is in baseball analytics.
So any idea how to hold the political end accountable for not doing what they should be doing?
I think this goes back to when I was testifying about H403, I think it was the bill on recidivism measures, 409. The bill on recidivism measures, and Ellen Whalen West from Council of State Governments testified after I did, and I had testified that I had wanted the provision that required data collection to be in statute, not just a suggestion, because I said if it's in statute, it will happen. If it's just a suggestion, maybe it'll happen, maybe it won't. And she testified after and said she really wanted to highlight that point, that in her experience working with state governments all over the country, when something's in statute, it actually happens. And when it's not, it doesn't. And so what I would say is we should, not this year, I don't think we have time for it this year, but we should be putting some benchmarks in place in terms of what type of data do we want to have? How do we want it to be accessible? And what dates do we want it to be accessible by? And take everybody who's responsible for that data, which is going to be the judiciary, it's going to be our office, it's going to be the prosecutor's office, it's going to be DOC, and have us all get together and, set up some dates that say, yes, here's when we could start to achieve these goals and start putting it into statute, because I think that's the way it actually will happen. And I think that it'll be, when we get to that point, it's going to be a miracle in justice, the execution of the justice system. I mean, already, if you look at Burlington City Police's dashboard, it is a wealth of information. It's so sad that we don't have that all over the rest of the state. The fact that you can look at Burlington and you can see in any given period of time, you can see where there's hotspots of calls, where there's hotspots of arrest, all of that, super valuable to us, super valuable for us looking at where are we seeing problems? Why are we seeing problems? Is this patterns in demographics? Is this patterns in policing? Is this patterns in, like, what are we looking at? And, Burlington Police has this great dashboard, and it's so incredible to be able to see all that data at such a granular level. You can see it by zip code within Burlington. But to be able to not have that in the rest of the state and to not have that in the sort of above policing level, like that covers, Burlington's dashboard covers policing. It doesn't cover the rest of the justice system that happens after policing. And we want to see that level of granular data for the whole thing. And it shouldn't be that impossible. I mean, all this data is already being collected. It just isn't being.
So just to be clear,
Yes.
as far as I know, we do have it. We just choose not to use it, and that individual groups choose not to get together to make it all work together.
I don't want to answer that in the affirmative in a way that diminishes
I don't blame you.
that diminishes the difficulty of the task that I'm proposing. It's a huge task, like
Heard it.
turning a lot of data that has never been collected and aggregated and distributed before into collectible and aggregatable and distributable data, especially when you have to account for some of it's going to be confidential and some of it's not. Heavy lift. I think it's an important lift and one we've got to get on.
But no question, but there's a lot of that data that is already out there that we already know about. We just choose, or somebody chooses not to bring it forward for one reason or another.
I think honestly, it's a resources issue. I've talked to Attorney McManus. I've talked to others involved in the system. We all agree that we all want more data. If you asked our office right now, can you take the data you have, segregate your confidential data from your non-confidential data, make that non-confidential data aggregatable and distributable to the public? I would say we'd really love to do that, and we would probably have to hire some people who know a lot more about this than I do, figure out how to do that. It would be so beyond our capabilities as an organization right now, and I imagine that's true for other organizations. The entire system is under-resourced around data and analytics.
So Tom and Angela, and if it could be on the bill, that's great, or it can be on data.
Data part, Valcourt is statewide now. It started in Burlington, but it's basically statewide. I think Spillman users, Spillman used to be the way to go. And then Valcourt came along. That was created by law enforcement. It was written by police chief of Burlington Police Department, that whole program, like Sherling. It's become Crosswinds, who now maintains it. I don't know why they couldn't just merge all that data into something else, the judiciary, but exclude the confidential data. Yeah, I don't know, but that's just.
And I do think, not to push off data, it's very important. We do need to continue to work on that. And, but I know I'm going to be losing people, shortly. So, but.
Well, I was going to remind all of us of the existence of the Division of Racial Justice
Right.
Statistics within the Office of Racial Equity, and that they are finding that they don't always have, the data they need isn't always kept. So there is this entity that's been created to, not to do exactly what you're talking about, Marshall, but like to do some of that work, and yet they are running into issues because the data is not kept.
And that's why I think ultimately, I mean, we're going to get there someday. It's not like the system is going to run in the dark ages forever, which is part of the reason I'd love to get there sooner rather than later. And someday when it happens, it's going to have to be a large effort with everybody involved.
And it will require funding.
Oh, yeah.
Tough right now. Yeah, anyway, proceeding.
So to proceed on, the next section that I'll address just very briefly is the Victim Notification System Task Force. We're not suggesting that our office should be a member of that task force. I don't think that it's really our interests that are central to that process, but I do think that we have some collateral interests in that. And so our suggestion is that just like the previous task force or working group, that this have a provision for entities that the task force consults with. And we would just ask to be added as a group that the task force consults with. I'll tell you just the reason for that is a lot of our attorneys, including myself, we use VineLink as our way of keeping track of our clients. It's not just victim notification. Anybody can go online and sign up for VineLink and get notification. And that's how I know when my clients are moved from facility to facility. It's how I know where to call my clients. So it is something that certainly touches on us, and we don't need to be included as members, but we just like to be consulted with in that process, just like the other committee has a membership list and a consultation list. The only other things that I will add, I'm done with anything in the bill, but I can briefly address the points that Attorney McManus raised. And that would be in terms of incorporating components of H410 into this. We would support that. We do think that, as was mentioned, we shouldn't simply change the definition of recidivism or eliminate the existing one, but we think that adding a definition that does not include incarceration is super positive step. We'd actually like to see all of the sort of granular components of H410 included in this. Plus, we'd like to see more, as we testified about H410. But if all we can get is adding a separate look that looks at, so that we look at reincarceration and reconviction, I would say that we think that reconviction should be studied with a time limit on it. 3 years is what's used in most of the country. That gives us a good ability to compare our data to other states. That said, if it's 5 years, if it's something else, that's fine. We just want it to be something that's set and where there is some finite time. There's a lot of research on the extent to which past criminal activity is a predictor of future criminal activity. And what that says basically is for misdemeanors, minor offenses, nonviolent offenses, after 3 years, a criminal history loses any predictive value of future criminal offending. For more serious offenses, that goes up to 5 and as high as 7 years for really serious offenses. But so we don't see there being any reason to look beyond that. So don't really care whether the number is 3 or 5 or 7, but we don't think that there's a reason to look at someone's entire life history. And, did they commit an offense when they were 18? And did they commit an offense when they were 67? But that's probably not actually a relevant data point, even if they did. That's why we would say limit it to something that's connected to the science, either 3 years, 5 years, or 7 years, depending on what type of offense you're looking at, or to what the science says and say we're going to look at misdemeanors through a 3-year look back lens. We're going to look at listed offenses and felonies under a 5-year, and we're going to look at, say, the big 12 offenses under a 7-year look back, something like that. So other than that, we support the state's attorney's proposal in terms of making sure that we include some components of H410 into this bill. As far as the proposal around changing impede to disrupt in section 7575, that's something I hadn't considered until today, and I'm going to have to spend some time looking at it. That certainly implicates some pretty serious constitutional considerations. I know that that's language that the Vermont Supreme Court has used, and I'm always hesitant to suggest that we change the language that's in statute that the Vermont Supreme Court has used to something else. But I'm going to have to go back and look and see exactly how it's been defined and whether impede could replace disrupt or whether that would produce some constitutional problems.
Well, it's the definition that matters for, if you add a definition to disrupt, that's where it's tricky perhaps, disrupt.
And ultimately, I think our office's position is that whether we use disrupts, whether we use impedes, anything where the legislature is sort of trying to change the definition is going to present a constitutional problem because the Vermont Supreme Court has interpreted this through a constitutional lens. And when they go there, they don't really care how the legislature says you should interpret it. That's when they sort of say, now this is when we look at, we don't look to legislative intent, we look to plain language of the Constitution. So that's, I'm going to have to look at that closer, but my preliminary take on it is that our office's position will be that it should remain as is. And if it's going to be addressed, it should be addressed through the court, not through the legislature. And I'm happy to answer any questions.
Any questions for I don't see, so thank you very much. I appreciate your testimony. And if there are additional amendments that are added on, we will let you know that, and you can decide whether you want to weigh in on those.
We'll be following it, so.
Yeah. This is one that gets followed. So tomorrow morning, we have S87 extradition procedures. We're going to have to take it up again next week as well, because there's some witnesses not available, including DOC and the office. And we'll also do a little more S109, including Chris Bradley and H230, including the General Counsel for Fish and Wildlife. So we're adjourned until tomorrow.